So may I just respond to this? There are two specific portions of my written submission, both the old and the new, where I've specifically addressed this. And can I volunteer to respond to this before I continue with this? Because the question has arisen from the bench. Since.
In other words, whether the rationality of that custom can be questioned in a court of law.
I'm so grateful. That's the question. And if I may make this humble submission, the rewriting of the rules of religion would be beyond the scope of judicial review under Article 32 and 226 is my humble submission. Since the question of rationality was raised, I think Justice Valali had...
Slightly different. But the power of judicial review, there is no need to attack on that power so much. That is, we understand that limitations are there.
Please.
But to say that there is no power at all, it may also be very difficult to you.
This practice is broader than religious worship.
I'm so grateful. That was the intent, because otherwise it also limits rights under 25(1). And therefore it was meant to widen up the entire conversation, both under 25(1) and 25(2).
So, and also it enables the state to make the law.
So grateful. That means
the law then.
I'm so grateful. That means the power of the state is not limited only to aspects of worship. It also extends to practice. I'm with my lady.
No, it doesn't extend to worship. It extends to practice.
Fair enough.
It is broad enough, but at the same time, it does not extend to worship should be the...
I stand corrected.
Yes.
Grateful. I am grateful for the nuance. I didn't think of it that way. I'm grateful for it. Kindly take a look at para 21, and I request my lady to kindly see Romans 1, 2, 3, and 4 for a moment at page number 14. My Lord Justice Kumar has it? Please. The term religious worship was replaced with religious practice in explanation 2. This explains the use of religious practice in 25(2)(a). Social reforms were made permissible with the consent of, kindly underscore the words, legislature. Which means this addresses one fundamental question across the board. Subject to clause under 25(1), enabling power under 25(2), subject to clause under 26 are powers to be exercised only by the legislature. Is a humble submission that all of that, which is why I think Mr. Gopal Shankaran said it is vertical in that sense, that the restrictions on those rights can be applied only by the state. And the state, my lady is aware, under Article 12 and 13, state does not include the judiciary in its judicial capacity. Mirajkar and several judgments have held to that effect. Therefore, for the purposes of this chapter or this part, the reference to state is to the executive and the legislature, and in my humble submission, it does not include the judiciary. Therefore, the question of entertaining any writ petitions, challenging those practices on the ground that it violates any of those subject to provisions, does not even arise, simply because those powers are limited to the state. And this perhaps could answer the question differently. I'm so sorry, my lady had something to say.
No, if the state, it enables the state to make laws.
Yes.
To bring in social reform, such as, for example, entry. Now, the question here is not, the controversy is not that the state has banned entry as such.
I understand.
State has made the law, rule,
I'm so grateful.
act and the rule for entry.
I'm so grateful.
Under that, because of the custom, there is a prohibition.
So can I...
In the Kerala Act and Rule.
My lady is correct. So here's what I have done.
Made a law banning entry.
Please.
State has made a law promoting entry.
I'm so grateful.
But under the custom,
Yes.
there is under the 3B rule.
Yes.
There it is an exception.
So may I just respond to this? There are two specific portions of my written submission, both the old and the new, where I've specifically addressed this. And can I volunteer to respond to this before I continue with this? Because the question has arisen from the bench. Codification of a pre-existing religious practice by the state does not make that practice amenable to judicial review, because it is not exercise of rights under 25(1) or 25(2) where limitations are imposed. The submission is, if judiciary cannot or the courts cannot preside over constitutional challenges to practices themselves per se, merely because the state rolls that practice by way of a legislation, that doesn't make it amenable to review, is my humble submission. Because at the core of it, my lady would still be getting into the question of 25(1) and 25(2) in that sense.
In other words, whether the rationality of that custom can be questioned in a court of law.
I'm so grateful. That's the question. And if I may make this humble submission, I am therefore applying the simple principle that what cannot be done directly can also not be done indirectly. So if you cannot get into the rationality of a religious practice, ipso facto, merely... My apologies.
The basic structure.
May I answer the question?
Yes.
I'm so grateful. And there was...
The role of the court is very restrictive.
I'm grateful.
A better argument.
I'm with my lords on the point, which is, in the process of entertaining those writ petitions to the challenge, again, ERP test cannot be applied, whichever way that route is, which is, The rewriting of the rules of religion would be beyond the scope of judicial review under Article 32 and 226 is my humble submission. Since the question of rationality was raised, I think Justice Varali had...
Slightly different, but
My
the
apologies.
moment you expand the wing of the state or the executive,
Please,
the
Minister.
power of judicial review automatically comes.
I'm so
If
great.
the state in the name of social welfare,
Right.
suppose prohibits a religious practice,
Right.
who will examine?
I'm so great. Can I answer this question? When the state, I'll just show one thing. Can I request my lords to kindly come to that portion of my written submission where I've answered this question straight off? Can I finish this and come to that minutes? Just so that the flow is not broken.
The power of judicial review, there is no need to attack on that power so much.
Fair enough.
That if we understand that limitations are there,
Please, minutes.
but to say that there is no power at all, it may also be very difficult.
No, Minister,
It's a
I agree with
hypothetical
Milord's point.
situation.
I
It will
completely
again depend upon
Please.
the situation and
Can I perhaps request my lords to come to page number 27? I'll show this at a later stage
Yeah.
where I've addressed this question. Allow me to just complete this train of thought.
Go ahead.
Please take a look at this.
Yeah.
My lords, I'll take some time. My lords may kindly come to para number 21. So social reforms were made permissible. The Kirpan explanation or the exception continues. Explanation 3 was omitted, which was civil obligation on certain religious institutions. Then kindly come to para number 22. In my humble submission, this extract from Sri K.M. Munshi is necessary to understand the purpose of 26. Kindly see this, and I think Dr. Dhawan actually pointed this out. Does the Honorable Bench have this? Kindly see para number 22. Religious freedom is meaningless if this clause is deleted, which is on clause 17, the equivalent of 26. Fundamental freedom of religion necessarily carries with it the right for a religious denomination to retain property, which means when denomination was used here, it was not in the sectarian sense, but to say any collection of people exercising their rights under 25(1) would have and would need the right under 26 to give manifestation to that right in an institutional form, to run institutions. Because at the end of the day, that belief also translates to charitable intents, educational intents, religious intents, so on and so forth. Then kindly see, this clause was not objected to by Dr. Ambedkar. He only rephrased it in a slightly different way, which is at the bottom of page number 14. No religious denomination shall be disqualified to manage its own affairs. That would cover the case. That was Dr. Ambedkar's suggestion. Then kindly come to the next page. So Article 17 or 26 was reworded in this fashion, which is extracted on the top of page 15. My lord sees that. This was the entire paragraph. And therefore, my lords, I go to the next page. So Article 17 or 26 was reworded in this fashion, which is extracted on the top of page 15. My lord sees that. This was the entire paragraph. And therefore, my lords, I made the point here that clearly the word religious denomination, there's a typo, it's not word, it's the word, was not meant to be used in a restrictive sense, since it was meant to give effect to religious freedom, which was available to everyone. Consequently, the term religious denomination has been used as a synonym for religious association. There are multiple typos here. My apologies for it. This was dictated last evening. Kindly come to para number 23. And my lords would see that on 22nd of April 1947, these were the revised versions. Again, explanation 2 continues with clause 16. Then my lords may come to the next page number 16. Page 16 speaks of clause 17. And then my lords may come to para number 24. This is the interim report of the Advisory Committee on Fundamental Rights of 23rd of April 1947 under the chapter Justiciable Fundamental Rights. So clauses 16 and 17 become the new 13, 14. They change numbers multiple times, but the spirit remains the same as my humble submission. My lords may then come to para number 25 on the next page. This addresses the second portion of 25(2)(b). At page number 17, para 25. My lord, Justice Masi has it. Please. The interim report of the Advisory Committee was presented to the Constituent Assembly on 29th of April 1947 by Sri Sardar Vallabhai Patel as the chairman of the committee. When clause 13 was taken up for discussion on 1st of May 1947, again it's Sri K.M. Munshi who proposed to add the words, and for throwing open Hindu religious institutions of a public character, kindly mark the words to any class, it should have been or section of Hindus. Class or section of Hindus. This was meant to be added to explanation 3. So kindly see explanation 3 on the top of the page, where it says, from enacting laws for the purpose of social welfare and reform, to that this portion was meant to be appended and said, and for throwing open. Now please note, class or section have been used as legal synonyms for a specific reason, because they were dealing with the realities of that day. And therefore, it always had a caste-based connotation. Is a humble submission. Whether my lords chooses to use the word class or section wouldn't make a difference. Then kindly come to the next page. Sorry, my lords would see. So after the addition of these words, on the next page at page number 18, the new explanation 3, which is proto.
25 2B.
I'm so grateful. So this is it. This